Imagine this. You have spent years in the US studying and working your way up, landed a job, and finally ready for your employer to file your H-1B. And then you find out that your visa cost $100,000. Well, what was once a ladder for your dreams has now suddenly become a golden gate. Well, what started as a visa for skilled talent now sounds like a golden gate, like I said. So, who really wins? Who loses? And how will this reshape America's job market? Today, I am joined by immigration attorney Kimberley Best Robidoux to unpack what might be the biggest shake-up to the H-1B program in decades. Well, before I welcome Kimberley, I am going to tell you that this episode is going to be a very interesting one and a very insightful one. So I would request all of you to join us on all our platforms, LinkedIn, YouTube, and Facebook. We are live also on Twitter. So make sure that you are tuned in on all these platforms, listening to us, watching us. And also, if you have any questions related to this topic or any other immigration topic that you would like to ask from Kimberley, you are more than welcome to do that. And now, without any further ado, let me welcome Kimberley Best Robidoux, immigration attorney, to Immigration Talk Show. Hi, Kimberley. Welcome to Immigration Talk Show.
Hi, Rajni. Nice to see you.
Nice to see you too. And before the show started, we were talking and you were telling us that how busy it has been for you and how hectic it has been for you. So thank you so much for being here. Thank you so much for taking our time and not postponing the show even after your hectic schedule. So thank you so much.
Yeah, absolutely. I know we're probably going to talk a little bit about why my schedule has been a little hectic this morning. So I'll turn it over to you to address that.
Absolutely. Thank you so much. And before I move ahead, guys, I would like to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, guys, I already have told you that the show is going to be very interesting and an insightful one. We are going to talk about H-1B and the fee hike and everything that you are looking forward to. But before I dive into that, I would also like to tell you that DHS has announced that beginning October 30, 2025, individuals filing to renew certain EADs will no longer receive the automatic extension that many have relied on. Well, this is breaking news that broke just, I think, a couple of hours ago. So it is, like I said, a breaking news. And Kimberley, we would like to come to you and ask you about what's your take on this announcement that has been made by DHS? And, it's kind of a breaking news, right?
No, you're absolutely correct. It is breaking news. You're getting it first time, right? It just happened today. I woke up on the West Coast learning about it. It was the first thing that I saw and essentially what I've been focused on for my day so far. It is very much breaking news.
So, Kimberley, how significant is this change? I mean, in practical terms for visa holders and their employers, and what risk does it introduce that weren't there before?
So, if I can give you a little bit of history, back in 2016, we had a process for many, many years where when someone filed an extension application for their employment authorization document, which we also call a work permit or an EAD card, if the Immigration Service did not produce the new EAD card within 90 days, then they were supposed to issue an interim EAD card to allow the individual to continue to work. Back in beginning of 2017, so there was a rule that went into effect right after Obama's administration and right as the first Trump administration was starting, which stated that the USCIS would no longer issue the 90-day interim EAD cards. The interim EAD cards, but instead there would be an automatic extension granted to certain categories of work authorization if the application for the renewal or extension of the EAD card was timely filed. And that automatic extension provided for 180 days of continued work authorization while the Immigration Service continued to process the EAD card. During COVID, because of restrictions with workers at USCIS, and also due to an incredible increase in the applications for EAD cards, primarily based on TPS and some of the parole programs, the period of time to get that EAD renewal was taking more than 6 months. So the government introduced a temporary automatic extension increase from 180 days to 540 days. And then in December of 2024, the Biden administration made that 540-day automatic extension permanent via the issuance of a regulation. So that has allowed individuals in certain categories, right? And those would be asylees, refugees, TPS, individuals with a pending application to adjust status. There's also suspension and deportation. There's several other categories that are eligible for an automatic extension of the EAD card as long as the renewal is filed timely with the Immigration Service. So that has been incredibly helpful, especially given the lengthy processing times for the government to issue the new EAD card. And this, they called it an interim final rule, was just released today. It was they released the notice that's in advance of what will actually be published in the Federal Register tomorrow, October 30th. And it's the publication in the Federal Register that means that it's a new regulation that the government is proposing. So this announcement today gives us the peek at what is going to be published tomorrow. And this rule will completely eliminate the automatic extension of EAD cards when renewals or extensions are timely filed with the Immigration Service. So that's a little bit of the history of what's happened in the past and to get us to where we are today. And now, as of tomorrow, individuals who file extensions or renewals of their EAD cards, where they once may have been able to get a 540-day automatic extension to continue to work, that will no longer be available for those applications that are filed on or after October 30th of 2025.
Okay. So, Kimberly, even lately, everything has been announced all of a sudden, like, right, a day before or a week before when people are not even prepared for it. So do you think this is going to be like a major shift, or people are going to be concerned, or it is going to create a chaos, in between people?
Right. You're absolutely right. This was announced, the sneak peek, so to call it, came out today. It will be published tomorrow in the Federal Register, and it goes into effect tomorrow. So it is definitely a bombshell. To have something huge like this go into effect immediately is something we've been seeing with this current administration. It is kind of unprecedented with a lot of regulations. There's usually advance notice given so that people can take action. Essentially, what can be done is anyone who is eligible to file an extension or renewal of their EAD cards, and they can do so online today, that might be the best action to take, so that they have that receipt notice that is dated before October 30th, and they would continue to be eligible for using that expired EAD card with the receipt notice for the timely filed extension before October 30th in order to have that work authorization continue for up to 540 days or until the EAD card is issued, whichever comes sooner. So that's one action that can be taken. The chaos that is ensuing right now and will continue for a bit is employers reviewing their workforce, looking to determine who are the employees that have work authorization based on EAD cards. What is the category on which that work authorization is based, right? Because the automatic extension is not available for every EAD card. And then how will that impact the individuals, right? Are they not going to be able to continue to work given that their EAD card will expire and they don't have a timely filed extension or renewal before October 30th? How will that impact business operations? So it's a big a big job, so to speak, for employers right now to review their workforce to make that determination and assessment of how their workforce might be impacted. It could mean that certain individuals will no longer have work authorization in the near future, which could have a tremendous impact on business operations. So that's a multi-front approach right now, is employees and individuals who would normally be eligible for the 548-day automatic extension to file their renewal applications online today, if at all possible, and for employers to look at their workforce to determine who's on EAD cards and who might be impacted by this ruling, so that the company can adjust their strategy and in a way that they can understand how it is going to impact their business operations and then plan accordingly.
Wow. This most definitely is a breaking news, because this news is something that is going to definitely break some of the immigrants, because they won't have much time to prepare, and then they are going to look for the attorneys and they are going to connect with them. And like you said, you have been busy since morning. So yes, this episode and all this information that you're providing, all these insights that you are giving in this today's episode, is definitely going to help them. And guys, if you have questions related to your H-1Bs or any immigration problem, so please drop them in the comments below. And also, if you would like to give us a call and speak directly with the attorney, you can give us a call on the number which is displayed on the screen, 436 425-436-6335, and make sure to put the access code, which is 988888. Now, Kimberly, coming back to you, what categories of EAD holders are most at risk of facing a work authorization gap because of this rule?
Well, there's a few. It's likely individuals who have authorization based on, it could potentially apply to some TPS individuals, can apply to asylees or refugees. It can definitely apply to individuals who have pending applications to adjust status. Although some of those EAD cards have been being issued for up to a 5-year period of time, but it still might impact a significant number of those individuals. There are VAWA self-petitioners, right? Those are the victims of abuse. It can also impact what we call life legalization. So really certain categories that we don't hear a lot about, but they do impact individuals that are in the workforce.
Okay. And what steps should someone in the renewal queue take to avoid getting caught without authorization?
I'm sorry, would you mind repeating that?
So I wanted to know that what steps should someone in the renewal queue take today to avoid getting caught without authorization?
Oh, so one of the things to do is to file the application for renewal or extension as early as possible. Usually the applications may be submitted up to 6 months in advance of the expiration date. So file those applications as soon as possible, so that it gives the Immigration Service that time, if they do take up to 6 months, to issue the EAD card renewal document. So file early. And then for those who have an EAD card that's expiring soon and they've been delaying filing the application, the I-765 application to renew or extend their EAD, if they're at all able to file that extension online today before this rule goes into effect, that's one action that they can take. So file early and as early as possible, and then file today if that's an option.
Okay. So guys, make sure to take, whatever that Kimberly is suggesting you. So take into consideration and do file early. And if you have any questions or confusion regarding it, you can get directly in touch with Attorney Kimberley Best Robidoux. And I think we can, soon there will be the link. There will be a link displayed on screen, and you can, click on the link and you'll be able to find all her details to get in touch with her. So make sure to file early, like Kimberly said. And now let's come back to our today's topic. We wanted to, we had planned to talk about H-1B fee hike and who all is it going to impact. So Kimberly, let's talk about that. So, what exactly has changed with the H-1B visa fee structure, and who has to pay this new $100,000 fee? I mean, by now it's already like clear to people, and it's already, you have, I think, once done a show with us, and you have also spoken about this. But still, I would like to begin the show, or this topic at least, with this question. So if you can, again, tell us something about it.
Yeah, absolutely. So the $100,000 fee was announced with the presidential proclamation on September 19th. And it was only October 20th, so a month after the announcement of the presidential proclamation, did we have additional guidance from the government. That weekend of September 19th, we did have some guidance that said, hey, anybody who had an H-1B petition filed or approved before September 21st would not be impacted by the $100,000 fee. And then there were questions after that about, well, who will be impacted if their H-1B petition was filed on or after September 21st? So on or before September 21st, this presidential proclamation with the $100,000 fee does not apply to those individuals. Individuals who have an H-1B petition that was filed on or after September 21st are potentially impacted by the $100,000 fee. And who does that apply to? Well, the government has come out with their guidance and stated that if someone is in the United States and has an H-1B petition for an extension of their status filed with the Immigration Service, they are not impacted by the $100,000 fee, even if they were to leave the U.S., apply for an H-1B visa stamp, and then return to the United States after the petition's been approved. Individuals who have an H-1B petition filed to change their status from a non-immigrant status to H-1B will not be impacted as long as they remain in the United States during the adjudication of that H-1B petition. And then if they choose to travel internationally after the H-1B change of status petition has been approved, they are eligible to apply for an H-1B visa stamp and then re-enter the U.S. without being subject to the $100,000 fee. And then in those circumstances where a company needs to file an amended H-1B petition for an individual because they have a change in their position title or a change in their work site, those petitions also will not be impacted as long as the individual remains in the United States while that petition is being adjudicated by the Immigration Service. And then once the petition has been approved with the issuance of the I-94 to show that they're eligible to remain in the U.S., then they also can travel internationally in the future, apply for an H-1B visa stamp, and not be subject to the $100,000 fee upon reentry to the U.S. And then we also have the category of change of employers, who, again, the same thing. If the change of employer petition is filed in the United States, the individual remains. If the H-1B petition is filed and the individual remains in the United States while it's adjudicated and it's approved with that change of employer and extension of status, then they are also not impacted by the $100,000 fee. What is impacted? So what is impacted is if there is an H-1B petition that is filed and it is adjudicated for consular notification, port of entry notification, or pre-flight inspection notification. So port of entry and pre-flight inspection are typically dealing with Canadian citizens, consular notification for everybody else. So if an H-1B petition is approved, but it is for consular notification, port of entry, or pre-flight inspection, the $100,000 fee does apply unless the individual has a valid approved H-1B visa stamp in their passport at the time of filing the H-1B petition. So that's the caveat there for the consular notification cases. So typically, if someone is in the United States when the H-1B petition is filed, remains in the United States, and it's approved to allow them to continue to remain in the U.S., they will not be subject to the $100,000 fee, even if they travel after. But if an H-1B petition is filed and it is approved for consular notification, pre-flight inspection, or port of entry, and the person does not already have a valid H-1B visa stamp in their passport, they will be impacted by the $100,000 fee, which will be required to be paid by the employer for the individual to then re-enter the United States.
Wow. Okay. I mean, you have already made everything very clear to our viewers that way in a lot of detail. But still, Caroline Levitt memo it clarifies that it is only going to impact I think the new petitions. It's only going to be for new petitions, not for the existing ones or the renewals. So I would like to understand and ask you that how much clarity do the employers and workers really have right now on this?
There's some clarity, but still not a lot of clarity. We still don't have confirmation that the employer is responsible to pay the $100,000 fee. But based on regulations with respect to the H-1B petition, the regulations specifically say that an individual who's being sponsored cannot pay any of the fees or costs associated with the H-1B petition, with the exception of possibly premium processing if that is not required for a business reason. So by what we've seen in law and regulation already, the $100,000 fee would be required to be paid by the employer. That's our expectation on that. So for some employers, they are now instituting in their contracts that if someone leaves the United States and becomes subject to the $100,000 fee, if an employer is not willing to pay the $100,000 fee, then the individual will likely not be able to come back to the U.S. With what the press secretary stated in terms of trying to clarify things, one type of situation that will be impacted most likely is, let's say that you have an individual who's been in the United States in H-1B status for a couple of years, has been working for an employer or multiple, or a couple different employers over the course of time. They're laid off, they leave the United States, and then they find another employer so that they can be sponsored for H-1B and come back to the US. Well, in the past, that would be filed as a new employment essentially, but it's change of employer in a way because the individual has already been counted against the cap and is not going to be subject to the cap because they were already counted with that prior employer. In that situation, as we look at it today, if that individual who has left the United States and is abroad, if they do not have a valid H-1B visa stamp in their passport, they will be subject to the $100,000 fee. But if they have a valid H-1B visa stamp in their passport, they likely will not be subject to the $100,000 fee. So that's the caveat that we need to consider for those change of employer situations or situations in which somebody has held H-1B status in the US for a period of time, had to leave the United States, and now is returning and needs a new H-1B petition filed on their behalf. So that's a concern, especially with some circumstances where an individual might need to leave the United States in order to get more time outside of the US to extend their H-1B maximum and then allow them to have an extension of H-1B status for up to 1 year based on a pending perm application. So we're talking about people who are going through the permanent resident process. These are really, really limited situations. But in those situations, someone who's held H-1B status in the US for many years might be impacted by this $100,000 fee as well. That's where we are waiting for additional clarification. We are also waiting to see how litigation plays out, right? There are 2 lawsuits that have been filed, one by the Chamber of Commerce and one by a group of organizations. They filed it in California. So depending on what happens with that litigation, it could eliminate this presidential proclamation completely. It could provide additional guidance. We don't know, right? So we're waiting to see how that plays out. And then the other thing to remind people is that the presidential proclamation said that this fee was in effect for 1 year, and then they may or may not extend it. So depending on how litigation plays out or if it's still pending, we'll still wait for additional guidance, and we might have a situation where this might end next September of 2026, or it could potentially be extended if no action is taken to eliminate it beforehand.
Okay, okay. Thank you so much for this detailed answer, Kimberly. It really helps a lot. And, I see a lot of people who have joined us who's constantly dropping their questions in the comment section. And guys, if you're enjoying this conversation and if this conversation is being helpful to you, so make sure to like this, share this video with anyone who you think can also be benefited by all this information, and make sure to subscribe to Immigration Talk Show. And now, without any further ado, let me take the viewers' question, Kimberly, because I think, Sid is here, and Sid, I think, has posted about 4 to 5 questions. So I don't want to delay that. And let me just quickly take his question first. He says, hi, if a non-US company with no office in the US wishes to apply for concurrent H-1B, then what is the procedure? Does it require an agent? Can you help with such H-1B filing?
I'm going to have to decline to answer that because it requires specific legal advice and getting into the particular situation. So sorry about that, but it does require a lot of specific questions.
Details, absolutely. Yeah. Okay, let's move to his next question then. He says, I-140 has been pending since last 13 months. So what would you suggest at this given time, given filing a premium might lead to an RFE, as officers might not be reading the petition carefully?
It's a 50-50. Sometimes submitting an RFE in order to get that adjudication within 45 business days pushes it along, and it might be issued without an RFE. And sometimes if that case is sitting on an officer's desk and they're like, I don't want to do it that quickly, they might issue an RFE so that they can get additional time to process it. So in those situations, I always say it's kind of a 50-50. People just, I don't like to say this a lot, but kind of go with your gut with, assessing that situation and deciding if you want to file to upgrade it to premium processing. But we don't have any definitive statistics that say upgrading to premium processing definitely, and more than 50% will result in an RFE. We don't have any definitive stats like that. So,
okay,
yeah.
Mm-hmm. Okay, maybe let's move on to his next question. He says, when on concurrent H-1B, what is the minimum hours to work for a second employer? How should concurrent H-1B hours be specified in petition if the hours vary per week from 1 to 10 hours depending upon employer?
Yeah, again, some of that is specific legal advice and how to prepare an H-1B petition. Overall, for H-1B petitions with a number of hours, the government is going to look at, is somebody working 5 hours with one employer and 5 hours with another employer? So what are they doing with the rest of their time? If the total H-1B time is only 10 hours, that could result in an RFE or some additional information, especially if the pay isn't sufficient enough to be able to support someone in the US. So those are all kinds of questions that go into assessing what would be the minimum number of hours that someone can work in a second H-1B or a concurrent H-1B petition. So it depends on how many hours are being worked in petition number 1, and then how many hours might be worked in petition number 2. So it does require an analysis of the whole situation.
Okay. And he also goes on to ask that, is there a way to gain visibility on what's happening on the H-1B 100K lawsuit front, and who are the plaintiffs? Should one become a plaintiff to be eligible to gain from the verdict? Wow, that's an interesting one. Would you like to do this?
Fun. Yeah, I mean, the lawsuits are online. The Chamber of Commerce has theirs posted on their website along with additional information, as does the organizations that filed the other lawsuit in California have information posted as well. There's different sites such as the American Immigration Council where people might be able to follow what's happening with the litigation and also follow what posts are being provided by the Chamber of Commerce, because they'll likely, provide information on the other lawsuit as well. Based on this time, I don't know if additional individuals can participate, but the way that the litigation, the lawsuits have been filed is to make it national and incorporate as many people as possible.
Mm-hmm. Okay. So one last question from Sid's side is, I don't have an H-1B stamp yet. So will the 100K fee apply when I go for first time stamping? Should one get the visa stamping before the 100K payment collection begins?
So it depends. If someone is in the United States and has an H-1B petition filed to sponsor them, and it's filed as an amended petition, change of status, change of employer, and they remain in the US, then they're not subject to the $100,000 fee. If they then leave the United States after approval of the H-1B petition and apply for a new H-1B visa stamp. But if someone is outside of the United States when that H-1B petition is filed, then they will be subject to the $100,000 fee if they do not already have a valid H-1B visa in their passport.
Okay. So thank you so much, Sid, for all your questions. If I'm sure you must have all your answers by now. If you have any more follow-ups, you can continue posting them in the comments, or you can also give us a direct call on the number 425-436-6335. Don't forget to put the access code, which is 988888. And if you would like to get in touch with Attorney Kimberley, so there's a link which is displayed on the screen. You can click on this link, and yes, you will be directed to her website, and you will get all her details, contact number, email over there. You can write an email to her. You can give her a call on her number. So yes, you can directly get in touch with Kimberley. And now let me take Robinson's question. And Robinson says, does the $100 H-1B fee apply to extensions, amendments, or transfers for current visa holders, or only to brand new petitions? I think you have already spoken about this and you've already clarified on this, but still, if you would like to, tell him something.
Yeah, so essentially, to boil it down, the H-1 or the H-1B $100,000 fee applies if a petition is approved for consular notification, port of entry, or pre-flight inspection, and the individual does not already have a valid H-1B visa stamp in their passport. So it's a way to condense it.
Okay. And he also has one more question. He says, are there any legal challenges or exemptions Indian professionals can leverage to avoid or reduce the impact of this fee?
So if someone is subject to the $100,000 fee, the company could file and request what's called a national interest exception in order to get a waiver of that $100,000 fee. So the company will have to meet 4 criteria. They're going to have to show essentially that there are no U.S. workers that can perform the job, or that this person is the best person to perform the job, that it's in an industry that this individual is needed, that the individual poses no national security risks. And there's one other criteria, which I haven't memorized right now, but that national interest exception request is to be emailed directly to an email address that's been provided, and it will be reviewed by the Secretary of the Department of Homeland Security. So we haven't heard of any waivers of the $100,000 fee being issued just yet under the national interest exception, but I'm sure we will begin hearing about those, given that it just went into effect last week, and companies are, looking at assessing the situation for these circumstances of whether if they cannot pay the $100,000 fee, does the national interest exception apply, and will they submit that? And that takes a lot of work to put all that documentation and information together. So again, stay tuned and see. I know we'll be hearing about that soon.
Absolutely. And also maybe you can just wait for the verdict of the lawsuit, Robinson. And after that, right? After that, maybe there will be some hope for, a reduction of the H-1B $100,000 fee. I think everybody's waiting for that. So,
yes.
So we have one more question that is from Emmanuel. Emmanuel says, how should Indian professionals on F1 OPT or STEM OPT prepare for the financial and procedural impact of transitioning to H-1B under the new fee structure?
So for individuals that are, in F1 status and they have OPT or STEM OPT, as of now, the clarification from the Immigration Service says that if there is a change of status petition that is filed and approved, then the $100,000 fee will not take effect. So if someone is in that situation, I know in years past, we have been asked to file H-1B petitions for consular notification so that individuals with OPT or STEM OPT could max out as much possible time using their OPT or STEM OPT so that they would then have more time in the U.S. After the end of their OPT and their 6 years in H-1B status would kick in a little bit later. That strategy no longer would be beneficial right now because it would mean the individual and the company would be impacted by the $100,000 fee. So to best prepare is to ensure that if selected in the H-1B cap lottery, do not travel at all. No international travel until that H-1B petition has been approved and the company and attorney authorized any travel to ensure that the $100,000 fee will not be in effect.
Okay. Emmanuel, thank you so much for your question. I hope you have got your answer. If you are looking for more, you continue posting your follow-ups. Kimberly, we have a question from LinkedIn actually, but it's related to EAD. So I know we need to have more details on these questions on EAD and on the announcement that has been made in the morning. But still, I would like to read it. Only if you're okay, you can answer, or maybe then we can move to the next one. So
if you read, yeah, that'd be great.
Sure. It says, does OPT EAD impacted for this new regulation of DHS ends automatic extension of employment authorization?
We're still digging into that. So right now we're looking at the end of the 540-day automatic extension. The best thing to do is to file EAD extensions as early as possible. So for the STEM OPT extension, that should not be impacted because that's been authorized under law, under a different regulation, but it still should be filed as quickly as possible.
Okay. Thank you so much for taking that up, Kimberly. And thank you, Ravi, for your question. I hope you've got your answer. We have a lot more, actually. So I think Nirav is here. Nirav says, given the green card backlog for internationals, could this fee hike indirectly accelerate interest in EB visa self-petition options like EB1A or NIW? And what legal hurdles should applicants anticipate?
It might very well result in increased filings for the green card. Absolutely, especially self-petitions. And then what was the second part of it? I'm sorry, I'm not able to see the question on my screen.
Okay, so no, it says, given the green card backlog for Indian nationals, could this fee hike indirectly accelerate interest in EB visa self-petition options like EB1A or NIW? And then it's about what legal hurdles should applicants anticipate?
Legal hurdles to anticipate, as we've seen today, and with the September 19th proclamation, we don't know all the legal hurdles to anticipate. There's surprises that keep popping up every day. The best you can do is, if you're eligible for self-petitioning NIW or EB1A, then proceed with that as soon as possible. If you want to continue with the permanent resident process in the U.S., and just be aware of any additional changes that are announced with respect to the immigration environment here in the U.S.
Okay. Thank you so much, Kimberly, for taking that up. Nirav, thank you so much for your question. I hope you have got your answer. Okay, so Sid is actually back and he says, thank you. Should people consider moving from H-1B to O-1? What is the USCIS processing times for O-1? Can one start working based upon the petition receipt?
So if there's a change of status, an individual cannot start working in the new category based on a pending receipt. So if someone is changing status from H-1B to O-1, the O-1 petition has to be filed timely and before the H-1B status expires or before the individual fails to maintain H-1B status. There is no work permitted in O-1 classification until after the O-1 petition has been approved and is valid. So, and there might very well be additional O-1 cases that are filed in order to bypass this $100,000 fee, if that will be something that would impact the individual directly.
Okay. And what precautions should one take to travel to the home country for first-time H-1B stamping at the consulate under these new rules?
We recommend, working with the sponsoring company and Immigration Counsel. A lot of times we're having people carry the information about the clarification of the policy, and so that it's clear that the individual is not subject to the $100,000 fee if they meet the criteria. And then just all the regular precautions that should be taken, when someone is traveling and applying for a visa to consular post overseas. Make sure you have all the documentation necessary. Make sure there's nothing in your background from a criminal perspective that might impact the ability to have that visa stamp issued and returned to the U.S. Or some people that may have been placed in administrative processing in the past. They might want to, think closely about traveling again, or plan in the event that they are placed in administrative processing again and are going to be outside the United States for several weeks or months. So just the regular precautions that immigration counsels have been talking about since January, with delays in processing, administrative proceedings. Administrative processing, and then just ensuring before leaving the United States that the individual has all documentation that's necessary for a visa application and for reentry to the United States. And again, checking with counsel to make sure that there aren't any additional policies that come into place from the time that they plan until the time that they're actually going to get on the plane.
Because that is something that's happening quite often these days, right?
I mean, with the September 19th announcement, right, with the presidential proclamation, there were so many people that were abroad for a holiday and business trips, and that had a huge impact. So we're a little wary of some kind of surprise announcement coming out again. So the best that anybody can do is just stay informed of what's happening and just double check before they leave the United States to see if there's any additional policies that have been put in place.
I think there's one pattern that I noticed that, all these things are happening mostly around the holidays time, right? And I think now that Christmas is coming up, people must be planning their vacations, or people must be planning to travel abroad or to go to their home. And only, and in these times, bombshell like these are being dropped, right? So
Yeah.
you think people should be prepared for that too, and especially with the Christmas coming up?
Yeah, exactly. Stay aware of what's happening, right? A lot of, when we were looking at things, it seems like a lot of announcements have been happening on Fridays. But this one happened on Wednesday, right? So it took everybody by surprise. But yes, I agree with you. I mean, the holidays are coming up. If there's a policy that would have a negative impact on immigration, they would have the largest impact during the holiday time. So just for individuals to be very diligent, double check before traveling, make sure you have all your documentation, so that you can, do the best with respect to reentering the U.S.
And Kimberly, speaking of the documents, what documents should the people should have with them all the time?
In the United States, what documents should people carry with them?
Yeah.
So individuals who are permanent residents should always have their permanent resident card on them at all times. It actually is a legal requirement to carry your permanent resident card with you at all times. For individuals that are in some type of non-immigrant visa status, carry your passport with your I-94 document. You could even carry, if you have H-1B or O1 or L, carry your approval notice as well as your I-94 and your passport. Again, you can carry copies of those documents of your I-94 and your approval notices. And then individuals who have some type of work authorization, so such as students in F1 status, where their I-94 doesn't show that they have valid status in the U.S. necessarily, then they would want to carry their Form I-20 and their EAD card if they have an EAD card.
Okay. Thank you so much again for answering the question, Kimberly. I think there are, one more question that has come from Sid is, how will the new proposed H-1B wage level impact existing H-1B worker on wage level 1 at the time of renewal? Will renewal require moving to higher wage level?
The regulation with respect to prevailing wages and the level 4s of what is going to result in a higher likelihood of being selected in the cap only applies to H-1B cap cases. So there isn't anything that has come out yet that addresses the prevailing wage and the use of prevailing wages for current H-1B holders. So that regulation that was put forth by the administration strictly deals with H-1B cap cases. which would be in March of this coming year.
Okay. Okay. And one last question is, if you were to file a NIW I-140 petition while the employer filing is pending for a year, what would be your suggestion to do with the existing NIW filing before or after you file a new one?
I'm sorry, I don't really understand that question, and it seems very specific to a particular question. Yeah,
I think it needs more detail, right? Because it's talking about filing the petition. So I'm sure the petition and all those details, a lot more details will be required to answer this question. So thank you so much, Sid, for your question. And Kimberly, I would like to come to you and ask you that, do you think could anyone actually benefit from this change? Or, is this a deliberate strategy behind making the H-1B more exclusive?
Oh, you mean making it more exclusive by essentially rewarding higher paying jobs?
Yeah. Higher paying jobs by making it rich versus skilled, because $100,000 is a lot, right? And not everybody will be able to afford that much. So do you think it's some kind of strategy, or do you think will somebody actually benefit from this change?
The strategy for the H-1B cap situation of saying that if the company is sponsoring an individual for a position that qualifies under level 4 prevailing wage, they'll get 4 chances of being selected in the lottery. Level 3 will be 3 chances of being selected. It really benefits the larger organizations. Smaller organizations in the United States rely heavily on H-1B workers. A lot of people don't realize that. There are a lot of small businesses and medium-sized businesses that might have 1 or 2 individuals in H-1B status that they rely on significantly because they have that area of expertise that makes them, unique and needed by that particular company. So employers in that situation where, they might be paying, the prevailing wage or higher, but the position is not deemed a level 4 based on the requirements for the position, are going to be harmed by that policy.
Okay. And so does this mean startups will now find it impossible to bring in foreign talent? And what about the smaller companies?
I don't think it will be impossible, but it is definitely going to be more difficult, and it's going to require more strategizing of how to make it happen. So that definitely has an impact for sure. It's a hurdle. It's another hurdle. It's an added complexity.
Okay. Thank you so much again, Kimberly, for taking that up. And also, I have one more question, which, some analysts at JP Morgan say this could reduce approximately 5,500 authorizations each month. So what kind of real world impact would that create in the labor market?
I'm sorry, are you going back to the H-1B?
Yeah, this is related to the H-1B question. Okay. So the analysts at JP Morgan Chase and Corporation, they said that this could reduce approximately 5,500 authorizations each month. So that's why I wanted to know that what kind of real world impact would that create in the labor market?
I mean, given that our unemployment rate is very low in the United States, that could make or have a tremendous impact on the economy. It could have a tremendous impact on the economy in certain areas that might rely, where you might have a company that relies on individuals that are in H-1B status to perform certain positions. So it can either have a national impact or a local impact, depending on where the workers are concentrated. So it definitely has that effect of hurting the economy to some extent. So I agree where they say that it's, well, I don't agree. I'm saying that where they mention that how is it reforming the system? I don't know how it is reforming the system, other than to say the United States is not welcoming to immigrants, which is not what most Americans believe, right? Most Americans very much welcome immigrants to the United States. I mean, the US is built on immigrants. So these policies will have a negative impact on the economy of the United States.
Well, it is the land of the free and home of the brave. So, and right now it's time to be brave, especially for the immigrants, right?
That's right. I mean, everybody is banding together to share information, to provide comments to these regulations, to file lawsuits against the government. So, these actions that are being taken by the administration are in fact being addressed by companies and individuals and, immigration attorneys, as well as some congressional leaders. People aren't sitting back. There is definitely action being taken against some of the proposals that will have a tremendous impact on the United States.
Absolutely. I mean, the lawsuit is being filed by the Americans themselves. So it says that whether Americans are against immigrants or not. So that speaks for itself, right?
Yeah, I mean, the fact that the U.S. Chamber of Commerce filed a lawsuit with respect to the $100,000 fee says a lot, because the U.S. Chamber of Commerce represents the businesses in the United States, and it takes it's a big deal that they filed the lawsuit against the administration.
Thank you so much again, Kimberly. And now we have a few questions from Facebook, so we would like to take those, and then maybe we can wrap up the show.
Okay.
Okay, so here is this anonymous participant who wants to know, hi, what is the current timeline that people are anticipating for H-1B transfer premium processing with the government shutdown? My job has been impacted and I'm hoping to get an offer soon.
Well, at this point in time with the government shutdown, because the Department of Labor is closed and they are not processing any labor condition applications, which is the first step for the H-1B petition, until the government reopens, the Department of Labor will not process those LCAs. And in fact, the system that is used to submit those applications is closed. So employers and immigration attorneys cannot even prepare the applications through the flag system so that they can hit the button and submit as soon as the government reopens. So there's waiting for the government to reopen. And then once the government reopens, given that it's now been shut down for 29 days, there's going to be a tremendous demand for those labor condition applications. I don't know if the government, specifically the Department of Labor, will be able to comply with the processing of LCA applications within 7 business days. So there might be a delay in that process as well. And then the Immigration Service, they might potentially allow for the filing of petitions with evidence of a pending LCA. That has not been confirmed. I'm just speaking out loud of some options that might potentially be available to help. But as of now, until the federal government reopens, those labor condition applications cannot be submitted nor adjudicated. And the Immigration Service, requires a certified LCA with an H-1B petition. So the long answer is, I don't know how much longer it's going to be, right? We're all desperately waiting and hoping that the federal government reopens, that our congressional leaders communicate with each other and get a plan in place to open the government as soon as possible. So until then, unfortunately, there are a lot of people who are impacted who cannot change jobs or might not be able to file extensions because we can't get those out.
Okay. Thank you so much for your answer, Kimberly. And anonymous participant, I hope you have got your answer. Let's move on to the next one. So the next one says, I am in the US. I changed the status from F1 to H-1B. I got the approval last week on the H-1B. I have my family on F2. How can I apply for H-4 for them, please?
All right, that is specific legal advice. In general, individuals who are in one status in order to change to another would file an I-539 change of status, and if they're in certain non-immigrant statuses in the U.S. If someone's status, the principal beneficiary has already changed to H-1B and the family members are still in F2, my recommendation is to speak to an immigration attorney immediately, because there might be some issues with that, potentially that filing. So that's generically an I-539 application is filed with the government. But in this situation, I definitely recommend speaking with counsel, most likely the attorney who filed that H-1B petition.
Okay. Okay. Thank you again for your advice, Kimberly. Let's move on to the next question. I think that's it. All right. I think that's it for today. Thank you so much, Kimberly, for being here. I think that's the question that we had for today from our viewer side, but you explained all of them in detail, and the answers were very insightful and very detailed, like I said. So thank you again for being here. Any last advice before we wrap up? Any last advice for our viewers who are watching this show and are, still and a lot of tensions about what should they do and what should they not?
Yeah, so just stay vigilant, stay tuned to the actions that are being taken by the administration, and just be aware. And especially if you're traveling, make sure to check in with your employer and or immigration counsel before traveling to ensure that you do the best that you can to have a return to the United States. And thank you for sharing the breaking updates today with this EAD card automatic extension regulation. So there definitely is a lot going on over here, and we appreciate your time.
Maybe you can, we can do one more episode whenever you have time. I know you're very busy, but whenever you can make time, we can do another episode on this topic, and that too in detail. How about that?
We can try to do that, yeah.
Thank you. Thank you for being to it, Kimberly. Thank you for being here. And guys, thank you so much for all your questions and for tuning into Immigration Talk Show and for posting all your questions and asking, sending those Facebook questions and all these comments. It's always amazing to have you here. And we are soon going to come up with Kimberly with another episode on EAD. So like I said, and she also agreed to it. So we are looking forward to that. And I'm sure you must also be looking forward to that. But for now, we'll have to take your leave. Thank you so much for being here. If you like the episode, make sure to like it, share it with someone who you think can benefit from all this information. And don't forget to subscribe to Immigration Talk Show. I'm your host, Rajni Bharara. We'll see you very soon. You guys take care.
Thanks, Rajni. Good to see you.
Thank you so much, Kimberly.